Thank you, Chair. Less than 2 hours ago, I spoke here in the Chamber about the Scally report and how sometimes it feels that all we seem to do is discover another failure of the state in relation to how they treat women, how they look after women's health, women's children, their rights in terms of equal pay and equal pension. And here we are again, less than 2 hours later, speaking about more failures. And I also referred, when I spoke then, about the trust that women place in our health system and how they were let down, and here we go again. In relation to this particular bill, Fianna Fáil is supporting this bill, which does strengthen and modernise the current law governing coroners' inquests. And I want to particularly pay tribute to Deputy Clare Daly, who proposed a set of changes in 2015. And her proposal was prompted by inquests into maternal deaths between 2007 and 2013, which returned verdicts of medical misadventure. And can I say, in particular, my party, Fianna Fáil, supports the requirement that maternal deaths will now automatically be the subject of an inquest, and the fact that the bill will also allow a coroner to inquire into a stillbirth where there is cause for concern, for instance raised by the bereaved parents. Between 2011 and 2013, if we take a snapshot of 2 years, there were 27 maternal deaths recorded. That's almost 14 maternal deaths a year. That is a very, very high number. Of these, only 3 were the subject of an inquest. And those 3, and I've reason for being close to it, because one of them was a friend of mine, married to a friend of mine, and that was Nora Hyland, and I remember her death very well in February 2012. And I remember on many occasions afterwards sitting with her bereaved husband and her motherless son, a very small baby, who was born about 2 hours before Nora passed away, and trying to understand the grief, the trauma, all the unanswered questions as to why this lovely woman had died. Lots of questions and absolutely no answers. And the other 2 that were granted inquests eventually were, of course, Savita Halpanavar and Sally Roulette. But I'm going to mention one other woman, and that's Dara Kivlahan, who had complications in Sligo but was referred to Ulster Hospital and died there. Now, the reason that I mention her specifically, I spoke to Stephen about an hour ago in terms of, that time and just the difficulties that they went through. And I remember when I was first elected here 2.5 years ago, he sent me a text and he said, "Well done." And he said, "I might need to contact you in relation to the automatic right for an inquest after a maternal death." And I was happy to ring him because, as we know, this only came in pretty much at the last minute, and to say I have that opportunity now to repay our friendship and to be able to talk about that. But he told me very clearly that lives could have been saved if there was an automatic inquest, because very sadly Dara died having been referred to Sligo and been brought up to Ulster. But her family had to fight and fight and fight to get an inquest, and during that fight another woman died, Sally Roulette, who was also referred to Sligo. And it turned out, after both inquests were done, that they both died of the exact same syndrome. And if an inquest had been done into Dara's death, well then the hospital would have known what to watch for, and more than likely Sally's life could have been saved, because the doctors would have recognised the symptoms. So, here we are 5 years later, and it should have happened before now, but it's happening now, and there are other changes that need to come in, but we need to move on it, and we need to talk about the good elements that are proposed in this. This bill addresses a key problem which the Minister referred to, which did cause and still causes great public unease, that in a number of high-profile cases, and some not so high-profile, regarding both maternal deaths and perinatal deaths, deaths occurring in hospitals which should have been reported to coroners because they raised issues of medical error and were unnatural deaths under the Coroners Act 1962 were not actually reported. And this certainly led to inconsistencies in the way in which maternal deaths have been recorded in official statistics. And a strengthening and modernising of our current law will allow lessons to be learned to prevent the reoccurrence of errors and of such deaths. And the bill will also allow a coroner to inquire into a stillbirth where there is cause for concern, and as I mentioned, raised in particular by bereaved parents. And we have to remember in all of this, these are incredibly sensitive matters and very private matters for traumatised mothers, husbands, partners and families, and the need to be dealt with in the most sensitive but the most professional matter. They should not have to fight to obtain basic information at a time when they are at their most vulnerable. Families through the years have spent years, wasted years, fighting for inquests into the deaths of their loved ones. And the fact that it has in the past proven really difficult to persuade a coroner to hold inquests into maternal deaths has resulted in a lack of transparency about the incidents and causes of maternal deaths. And as I said, this absolutely prevents lessons being learned that could prevent the reoccurrence of errors. And the inconsistencies with which maternal deaths have been recorded have led to significant underreporting of these incidences, because I myself was quite shocked when I learned of 27 maternal deaths within 2 years. I couldn't believe that it was that high. Decisions of the European Court of Human Rights have stressed the obligation of states to investigate unexplained deaths or those that occur in circumstances that involved official persons or authorities. The Court has explicitly pointed out that the state's obligation can extend to deaths that occur in hospitals so as to be able to establish the cause of death and any liability on the part of health professionals. And it is clear that this legislation is required to ensure that Ireland is compliant with the European Court of Human Rights. On a broader note, bereaved families and coroners have experienced considerable difficulty in obtaining basic information which should have been provided to them. They should not have to fight to get this information. So the increased powers afforded to coroners by this bill is very much welcomed. And I say to you, Minister, that my party will bring forward amendments at committee stage to help strengthen these provisions. A complete reorganisation of coroner services under a national coroner services, as was envisaged by 2 previous bills, a government bill in 2007 and Deputy Clare Daly's PMB in 2015, is not provided for in this bill. This bill did not go through pre-legislative scrutiny, and so it's not clear what your government's rationale is for limiting the extent of the overhaul. And we want to know why, and once the government have outlined the reason for this, we will consider the merits of that decision or decide not to support that and to bring in our own amendments in relation to it. I think that it's important just once again to look at the main provisions, and those being, and I'm just going to pick out the most significant and important ones. Number 1, to provide for the new categories of deaths that must be reported to a coroner: maternal deaths, and late maternal death. And the definition of late maternal death is the death of a woman more than 42 days but less than 265 days after the end of her pregnancy. Stillbirths, deaths of infants during birth or in the first year of their lives, deaths by suicide, deaths by drug reactions or overdoses, deaths that may be due to a healthcare acquired infection. Item number 3, section number 3, which allows inquests to examine the circumstances surrounding a death and not just the cause of death, as is currently the case. This will not entail the coroner considering questions of civil or criminal liability, but rather the coroner will be concerned with establishing the circumstances of the death as distinct from making findings in respect to it. Section number 4, enhancing the powers of the coroner to procure post-mortem examinations, to obtain documentary and other evidence, to summon witnesses, to apply for search warrants, to take evidence from a witness who is likely to be outside the state at the time of an inquest at any time before the inquest, and to obtain expert advice or assistance. Section 5, new offences for failing to abide by requests of the coroner. Failure to answer a question at an inquest is an offence. A new offence of giving false or misleading evidence to an inquest. And section number 6, improvements for families of deceased persons, which provides for families of deceased persons to be kept informed about the work being undertaken by a coroner. Communication is absolutely vital to families that are going through grief. We heard again, I mentioned the Scally report earlier, and a doctor's response to a woman was, when she asked, when will we know? You'll see it on the news headlines or you'll see it on the television. We absolutely cannot and do not want that here. And it also provides for civil legal aid to be provided for families of deceased persons. I acknowledge that the Minister has indicated that he will, subject to advice from the Attorney-General, seek to put forward amendments at committee stage to authorise coroners to inquire into stillbirths where there is a cause of concern, and to allow a coroner to seek directions from the High Court on a point of law in relation to the performance of their function. Also, to provide for coroners to direct a hospital to make available the medical records of a deceased person, providing for the Minister to make regulations on the proper storage and disposal of any material removed during post-mortem examination. Minister, you mentioned when you spoke earlier about the public unease that all of these very sad cases brought about, and you were right in that, because there was huge public unease. But we absolutely have to remember the private grief, the private trauma, the private sorrow of lost daughters, sisters, wives, partners, mothers, friends. And we have to make sure that in cases, I would love to stand here and say we'll never have a maternal death again. Of course we will. But we have to ensure that when there is a maternal death, that all the supports of the mother's family will be met, and that straight away there will be a post-mortem into the death and into all of the circumstances surrounding it. I commend this bill, and I also wish to commend again Deputy Clare Daly. Thank you.
Thank you very much.